Hello, everyone. We're so excited folks from across the country could join us today as we discuss the new administration's latest actions around immigration and how they impact Tahirih's clients and our work. My name is Sahra Agahi, and I'll be moderating the presentation and discussion today. I invite you to please share your questions with us in the questions chat feature seen on your screen, as there will be an opportunity for our presenters to engage with them. At the end of this webinar, you'll receive a short survey to gather your thoughts. Your feedback is extremely valuable and helps us identify other topics you may want to explore further with us. We'd appreciate it if you take a minute after the webinar to respond to the survey. Now, I have the distinct pleasure of introducing a few of my incredible colleagues and today's presenters, Adriana López and Adilene Nunez-Huang, Tahirih's co-directors of client advocacy, as well as Archi Pyati, Tahirih's chief of policy and communications. Archi, Adriana, and Adi, thank you so much for being here with us today. Adi, I'll turn it over to you.
Good afternoon, everyone. Thank you so much, Zahra, for that beautiful introduction. My name is Adilene Nunez-Huang, and I will speak with you a little bit about the overview of the executive actions that we've seen come down since January 20th of this year. Then we'll move on to talking about the impact that these actions have had on our casework. And then we'll hear about how this has impacted our clients. And then we'll close out with Archie talking about some policy priorities that we have, and we'll leave an opportunity for folks to ask any questions they may have, any curious thoughts they may have the last 10 minutes of the presentation. So please feel free to use that chat feature and put in your questions, and we'll monitor that and we'll be sure to answer your questions. All right, so diving into an overview of the executive actions. I want to start by highlighting two things for everyone. The first is that a majority of the actions from the new administration call for agencies to review or evaluate programs or policies, regulations, or pending litigation as it relates to the orders that directly impact our clients and our casework. The second is that it's still too early for us to really know the outcome of those reviews or evaluations. So while it may feel like there has been a lot of movement in the immigration realm, we still have a lot of the same policies and a lot of that same environment in place that our advocates and our clients will continue to have to deal with for many months to come. And we're hopeful that we can see some positive impact for our clients sooner rather than later. So we want to first talk about the restoration of priorities. And when we talk about priorities, we're talking about immigration enforcement priorities. So that's when ICE officers are arresting people, putting them in detention, and then they go through that process. The clients go through that process. So a 2017 executive order flattened enforcement priorities. So that means that all undocumented immigrants were equally vulnerable to arrest and removal. Prior to that, there was sort of a hierarchy, if you will, of who would be a priority for ICE to come after. But in January 20th, we saw an order that specifically revoked that 2017 order, and immigration enforcement priorities were restored. And so you'll see here the 3 bullet pointed list of what those priorities are. DHS, which is the Department of Homeland Security, issued a policy memo calling for only people who fall into one of those 3 categories to really be the focus of arrest and deportation. And we're talking about national security risks, so something really big. If you're a recent reentry or recent entry, and they give a date of November 20th, or if there is some kind of threat that this non-citizen poses to public safety. And there was also a call for a review of those enforcement practices. And again, it's that review that we're talking about that isn't something that we saw immediately happen, and that's supposed to happen within those first 100 days. And next slide, please. And as we saw in that Department of Homeland Security memo, There was also a 100-day pause on removals, which was really amazing, actually. There was a lot of publicity of it, a lot of media coverage, and we were all really hopeful of what this could mean for our clients. However, we quickly saw that litigation followed, specifically from the state of Texas. And a judge agreed that the 100-day moratorium on removals, the pause on the removals, should be paused. And so then that really only applies to the 100-day moratorium part of the DHS memo. Everything else in that memo is still in place. So for instance, removal priorities, that DHS memo laid out quite specifically a very, very narrow categories of individuals who could be enforcement priorities. So that would include those also suspected of terrorism, that reentry again, and anyone who has voluntarily agreed to leave. There's also that fourth category that raised a lot of questions for folks about those who are required to be removed by law. So those removal priorities do remain in place. And so thankfully, one really great thing that we also saw in that DHS memo that was really positive for our clients was the rescission of what was affectionately called the NTA memo of 2018. Now, an NTA is a notice to appear. It's a document that begins the removal proceedings, so immigration court proceedings against a non-citizen. And that 2018 memo caused a lot of harm, a lot of hurt really to our clients and to other non-citizens in the country, because what that meant was that as soon as your application for immigration benefits was denied, then you were at a higher risk of being placed into removal proceedings. And you know, it was really terrible for our clients because we had to kind of prepare them for what that could mean for them. And it's a lot of holding of clients' feelings and really trying to manage expectations. It didn't mean that we weren't going to do our best. It just meant that there's always that heightened risk that clients could be placed into removal proceedings. So further elongating their sort of limbo status. But with that rescission, that added fear, the added climate of fear is not there anymore. So that's one really positive thing that the DHS memo was able to do for non-citizens in general, but specifically for our clients. And we're really, really happy that that happened. Next slide, please. So another thing that we saw come down through executive action was essentially an attempt to increase access to the immigration system. So a removal of barriers to accessing the legal immigration system, identifying agency actions that promote access, and recommending some next steps to revise and rescind any actions that would create those barriers. And we saw some timelines put onto that. So 90 days for those agencies to submit a plan, and 180 days after that plan is submitted for agencies to direct a report to the president. So we see this a lot in these actions of reviewing, reevaluating things, and putting these timelines for those reviews for action plans to be put into place, for reports to be issued. Next slide. Many of you may have heard of something called a public charge ground of inadmissibility, and it was something that was really impactful for a lot of non-citizens because it meant that individuals who could be seen as potentially in the future, if they're granted an immigration benefit, if they could be seen as they will end up needing to rely on government benefits, then that would make them what's called inadmissible. So basically saying you're not allowed to come into the US and you're not allowed to have your application granted if you're already in the US. And that also caused a lot of harm to a lot of non-citizens because there was a chilling effect. There was a lot of, it also added to the climate of fear that was already in place in immigrant communities. There was a carve out, an exception for essentially for Tahirih clients where the majority of the work that we do for our clients. So there was a carve out for asylum, for U visas, T visas, VAWA work, and special immigrant juvenile status, and then those individuals seeking to obtain a green card through one of those underlying benefits. So why are we talking about it, right? So it's a huge impact on non-citizens in general, and it did add to the anxiety that our clients were feeling. So even though it didn't necessarily impact their case, maybe they had a family member that it impacted. Maybe they were hearing things in the news that really confused them because you can't really control the messaging that you hear. So with a February 2nd executive order, the president ordered review of all agency actions related to the implementation of that public charge ground of inadmissibility. And here, you can also find this language directly in the order, but here's just a quick rundown of what that really means. To consider the effects and the implications of this policy and to identify steps to address any concerns related to the integrity of the immigration system, importantly, the public health, given the global pandemic. So again, you'll see 60 days to report to the president on actions identified and taken. Next slide, please. And here we're going to talk about two February 2nd orders that did two really interesting things. The first is an order called for regulations to define quote unquote social groups to make it possible for survivors of gender-based violence to perhaps more predictably be granted asylum. And this is something that is integral to asylum eligibility, a social group formulation, which Archie will touch on later. But calling for regulations to define this is sort of revolutionary in my opinion, because it's not something that's defined currently in regulations. It is the source of significant litigation as to what it could mean, who fits into this, how do you analyze it? And so calling for regulations to define this is really, it could be revolutionary for asylum seekers. And then there was another order that created a task force for reunification of families. This was also highly publicized a couple of years ago about what was known as a zero tolerance policy for folks coming into the country, where families were separated from so parents were separated from their children. There were reports of the children getting quote unquote lost in the system. And so really this is the first that we're really seeing an administration recognize that there is trauma and that the trauma causes a significant amount of harm to individuals. So it calls for the creation of this task force. The task force is charged with identifying children separated under that policy, the zero tolerance policy, and to facilitate the reunification, quote unquote, to the greatest extent possible, with recommendations about parole, which is a specific immigration term, a permission to enter the country, trauma and mental health services, and reunification of other family members with a focus on consultation with the children and their families. So this is a focus on people. This is a focus on that trauma, the impact, the horrible impact that the separations have caused. And of course, periodic reporting. Next slide, please. And so then we also saw the MPP program, which is the Migrant Protection Protocol, also known as Remain in Mexico, that was paused, and it will be reconsidered. There's no certainty here what this means yet, so we're hopeful that it can mean a better access to justice, a better access to the immigration system, the asylum system for folks who really need protection. State of emergency at the border ended, which also ended asylum bans. It paused building of the wall and redirected funds as well. Some COVID restrictions remain in place and some increased. And other policies are also to be, the quote unquote reviewed, evaluated, and redesigned. Next slide, please. So now we will be talking about the impact for immigrant survivors.
Want to hit next slide?
Thank you. I will be focusing on the impact on our casework, and Adriana will be focusing on the impact on our clients. So, as I had stated earlier, it's still way too early to really feel the impact of what these executive orders could mean for our clients and for our casework, since most call for the review or evaluation of things. But our staff welcomed with open arms the rescission of that NTA memo. I actually had a legal team member yelp with glee when I shared that news with her, because that policy, like I said earlier, caused so much harm, so much mental anguish. And it really, we saw USCIS really run wild with that NTA memo, with placing folks in proceedings. And it really prolonged our cases, and it kept folks in that state of limbo. And in a lot of circumstances, it meant that our staff was extending the work from the affirmative process, which is anything before the U.S. Citizenship and Immigration Services, extending that work into defensive, so into the immigration court. And in turn, it also increased our removal defense practice. But for now, we're hopeful that we'll see fewer notices to appear if we were to receive a denial. And that would hopefully also mean a less stressful process for our legal staff and for our clients. One curious thing that I've been observing in the last month or so is the cancellation or postponement of immigration trials. I'm not sure if you're aware, but when someone is in immigration court, that person can be in that process for several years. I think the fastest I've ever seen is maybe 3 years, but right now the longest I'm seeing is over a decade. And when these hearings are canceled or postponed, there could be a variety of reasons for it. It prolongs that experience of being in removal proceedings and everything that comes with it. But I've seen at least 4 of our immigration trials in one office in the last month or so that were canceled. They were scheduled to go forward from January 20th, actually January 15th onward, that were either completely canceled or postponed. I saw one get postponed to 2024. And now, while we cannot attribute this with any degree of confidence to anything, because there are plenty of reasons for that, I can't help but wonder if it has anything to do with what we're seeing with these orders and the review of things like particular social group regulations and the like. It's merely an observation of mine over the last month or so. But as you know, as always in our work, we're always keeping an eye on the problematic matter of AB litigation and what the particular social group definitions could encompass in the months to come. And as I said earlier, Archie will talk a little bit more about that later. And strategically, we are evaluating our cases, our removal cases, so cases in immigration court, and taking a real close look at them and seeing whether it is to the client's strategic advantage to postpone a hearing, so to seek a continuance, you know, on the off chance that the client might be in a better position to succeed and gain protections and to gain that stability in her immigration status if the legal landscape looks differently. It's something that we're considering, and of course, always in consultation with the client. But just given the fact that we are still currently in the same environment, for instance, matter of AB is still in the books, it's still being litigated. We still don't have that regulation on a particular social group. Some of the judges that were put into place, several months and a couple of years ago, they're still there. So we still have that very similar climate of fear in immigration court. So we're still in the throes of that. And I don't know that we'll be able to feel a positive shift for our clients for a couple of months at the earliest, but probably a little bit longer. And we're also seeing our cases drag on. So we were seeing this earlier, and we continue to see this now. As I mentioned earlier, we've had at least 4 trials postponed. A couple have been flat out canceled with no idea as to when in the future they will be rescheduled, and a couple have actually received a date for the future. I talked about that 2024 date. And for us, what that means is it actually means that it puts our legal advocates in a bit of a bind. So as these cases take longer to complete, as these cases take longer for our clients to see success and justice, our advocates have to carry this caseload with them for many, many years. And there's a balance that we need to strike here of responding to the needs that we see in the community, doing everything that we can to help survivors access justice and safety, while at the same time making sure that our staff are able to take that load. And it truly is a delicate balancing act that is sometimes complicated by things that are significantly outside of our control, like policies and regulations. But with the support of our generous donors and funders, we are able to continue doing this necessary work. And we hope to continue to do that with your continued generosity. Adriana?
Thank you. Next slide, please.
Thank you, Addie, for that incredible overview on the executive actions. What I really want to do today, while I'm speaking to you all, is to help contextualize what this all means for our immigrant survivors and their day-to-day lives. For many of us advocates who have been in the trenches for a while, we know that all of the back and forth, the sort of fast and furious announcements on immigration, whether they are executive orders, court decisions, etc., coupled really with quick sound bites from media, often create a lot of confusion, and depending on what the content of the order is, fear in our clients. We know that the immigration system is very complex, and so it's really important for organizations like the Tahirih Justice Center and our advocates at Tahirih to spend time talking to our clients so that they truly understand what these things mean for them, and so that they can make informed decisions about their lives. Sometimes they hear in the news something that they think is positive, and then they're disappointed when they talk to one of our advocates and they realize that the situation is a little bit more nuanced, and that there are no quick fixes. On the flip side of that, sometimes they may hear something and on the news and may interpret it as being negative for them, when in reality it does not apply. And I know Addie talked a little bit about the public charge inadmissibility, and I'll never forget when the public charge or executive order around the public charge came out a couple of years ago, sitting with one of my clients who was pursuing an asylum case, who had a daughter, a 3-year-old daughter who's a US citizen, and she had heard in the news that this was happening, that the order, was being put in place, and or that the order had been issued, and she automatically thought that it would impact negatively her asylum case, and ended up unenrolling her daughter from Medicaid because she was
scared of the repercussions. And so these kinds of fast and furious announcements without having access to the right information, accurate information, really does have life consequences for our clients in their ability to access services and social safety net programs that oftentimes they or their families, right, legally qualify for. And so it has a chilling effect on them. Addie also talked about the fact that we are seeing, one of the orders talked about a more targeted, more narrow focus on enforcement priorities, which may influence help-seeking behavior from immigrant survivors when they are seeking safety or trying to find safety. The reality is, though, that we have seen a slew of harmful policies and practice over the last couple of years that have been implemented and have created that chilling effect that we keep talking about and have exacerbated the distrust from agencies that are typically they're supposed to be there to provide support to survivors. We also know, if anything became clear in 2020 for all of us collectively, that communities of color, immigrant communities tend to be over-policed, that there are significant health inequities in the healthcare system, all of which directly respond and are at the front lines of the systems that our immigrant survivors interact with. And so it will take, I think, a number of years to really help center and rebuild that trust, and that there are actions, aligned with that, so that survivors can feel like they can reach out to agencies to support for their safety. Addie also talked about the long waiting times for either processing applications or trials that are being canceled or postponed, which means that our clients continue to be in limbo for many, many years. What that means for our advocates, and Addie talked about it from the legal perspective, from the social services perspective, because at Tahirih we approach our support to survivors in a holistic way, understanding that the legal component is just one aspect of their lives, and that they need added support systems to be able to really reach safety and stability and hopefully heal and thrive in their communities. And so right now, with the chilling effect, right, of all of these different policies that had been implemented, with the continued, the fact that the cases continue to take very long and can take up to a decade sometimes for our clients, and coupled with the fact that we are experiencing a global pandemic, it means that for our advocates, we're continue to operate in a crisis mode where we are trying to just help our clients meet basic needs. Next slide, please. I think the other reality, right, I talked about COVID. The other reality is that gender-based violence is a shadow pandemic. It was happening before COVID, and it continues to happen now, and it's only been exacerbated. It is a serious public health concern. We know for a fact that survivors of gender-based violence are significantly more likely to experience the negative short and long-term health outcomes, which include things like injuries as a result of the abuse and the violence that they've experienced, chronic health problems, depression, post-traumatic stress. They're 3 times more likely to develop gynecological problems. And we know that the violence is also associated with detrimental health outcomes to mothers and infants. And you couple that crisis with the fact that we have a global pandemic where we are seeing inequities in who is able to access healthcare services and the multiple barriers that particularly impact immigrant communities, communities of color, Black and Brown communities, we are talking about another urgent crisis that continues to be overlooked. And we know from our practice day to day, our advocates see that, you know, our survivors are sometimes forgoing you know, going to their clinics or their hospitals to get the medical services that they need because there are, whether it's financial or lack of health insurance or otherwise, that they're just not accessible to them. And so it's something that we need to keep at the forefront when we are thinking about the unique needs that immigrant survivors have, particularly because we know that they haven't necessarily, they don't qualify for some public health benefits. They also weren't included in the CARES Act, any like COVID relief. And so our immigrant survivors are being left behind. There's also this competing tension or competing notion of safety during COVID, which is, you know, I either stay at home and face increased financial stress because I am trying to stay safe from the pandemic and not contract the virus, or I risk you know, going outside, finding a job, oftentimes precarious jobs. You know, a lot of our clients who are able to work, which many don't, but those who do are, you know, represented or overrepresented in essential work. We have clients who are nurses, who are teachers, childcare providers, who work in grocery stores, and so they are overrepresented in industries that are at increased risk of contracting the virus. And so there's, again, this competing notion of safety for our clients in terms of COVID. And then there's also the risk of re-victimization, which, you know, in talking to a lot of my peers in the different offices, we're spending a lot of time doing safety planning and addressing urgent safety concerns for our clients, whether it's through relocation, whether it's like financial support for housing, but always attached to the potential that perpetrators, whether there are the perpetrators that caused them to come to Tahirih in the first place, or whether they are current partners, right, that where the relationship becomes abusive, that we are seeing consistent with what agencies that work on public health issues related to domestic violence are saying, which is that domestic violence and re-victimization is something that is happening to immigrant survivors. And so it's something that we also have to keep in mind, particularly because we are facing this isolation. We are supposed to be physically isolated, and so it provides an opportunity. It creates vulnerability for our clients, and it provides an opportunity for abusers to exercise their power and control. And they may, even if they're not living together, they may understand the vulnerabilities that our clients are experiencing and may take advantage of that. You may have heard that, you know, every 3 months we know that there's going to be, we are uncertain about what evictions are going to look like, but we know that our survivors are experiencing significant homelessness. The domestic violence, including sexual violence, is reported as an acute cause of homelessness, and we know that between 22 to 57% of women who experience homelessness are because of intimate partner violence. The National Network to End Domestic Violence reports that 65% of victims' average unmet requests for help from domestic violence programs nationwide are related to housing services. These are unmet needs. 65% of survivors are requesting services related to housing. And so I know that that is also consistent with what we are seeing or what our advocates are seeing on the ground when we are talking to survivors, because housing is one of the greatest needs that we tend to try to support our clients with. And then it goes without saying that we are all collectively experiencing the trauma from the global pandemic. And so when you're thinking about all these different vulnerabilities, right, the constant back and forth, the confusion, the fear around what is happening with immigration, whether they are going to be able to stay, whether they are, whether they are at risk of being deported, coupled with the number of things that I just laid out for you, inability to access healthcare, the overexposure to the global pandemic, the risk of re-victimization, homelessness, that creates or it compounds on the trauma that our clients had already experienced. And so there's a critical need to make sure that survivors have the support to access mental health services. Next slide. I'm going to turn it over to Archi.
Thank you so much, Adriana and Adilene, and I'm really grateful to both of you for your presentations. And so obviously to all of you who've joined us today, thank you so much for being here and to listen to us speak a little bit about some of the executive orders and the impact of not only those shifts on our clients, but also the COVID pandemic as well. It's been phenomenal to hear a little bit more about the impact on our clients in particular. As you all know, we represent through 5 locations thousands of individuals. We've represented and served, I think, about 30,000 at this point in our history as an organization. But we also have maintained a policy practice for many years, the reason being that many of our clients are dealing with systemic issues that go beyond the trauma that they've experienced in their own lives, in their personal lives, when they finally are able to reach out and seek protection from the law and seek immigration status. Maybe they find a Tahirih attorney like the ones, the folks at on this call, an attorney or a social services provider. When they reach out for help, they also are dealing with a system that is constantly changing and in fact was broken even before these last 4 years. Now that we have seen a number of changes come rapid fire these last couple of weeks, we want to make sure to underscore that while these are steps in the right direction, there are still many, many open questions. This is important to underscore not only because many people are confused who are directly impacted, but also many in the general public and the media are sort of trumpeting the shifts and saying, look, all of these policies are now going to be revoked and everything is going to be fine now that we have a different administration. But the truth is, we really don't know what is coming. Yes, some of the policies have been outright revoked, but in fact, there are many that have not, and we don't know exactly what will happen to those. So we've covered a few that are especially relevant to our clients in this webinar today, but there are many more that have been, many more policies, big and small, that have been adopted in the last several years, and those have not yet been revoked. So we know that these next few years ahead of us are going to be focused on trying to overturn some of those harmful rules and policies. We also don't know, because we are litigating along with many of our partners many of those bad rules. We don't know if the administration intends to continue to defend those rules. Right now, we are sitting in postures across the country in different courts where we have filed complaints, our peers, our partner organizations have filed complaints, maybe we are counsel, maybe we are plaintiff. We're waiting to see what decisions the courts will make, and also whether the government is going to withdraw its defense of those policies in those legal actions. So that all remains to be seen, and we will be keeping you updated as our allies in this fight to help make sure that you know exactly what's happening with all of these policies. We also don't know exactly what the practical implications are of some of the policies that have been revoked. For example, you heard earlier about, we heard a little bit about the migration protection protocols, also known as Remain in Mexico, which had thousands of individuals kept on the other side of the southern border without access to attorneys as they waited to come across and make their asylum claims, having to stay in Mexico without the ability to come to the United States, be inside communities here, receive social services and other supports while also accessing attorneys, really stripped those immigrants of their rights as they were trying to, as they try to make their claims. We saw the Department of Homeland Security put a pause on MPP and say we won't enroll any more individuals. As you heard earlier in our presentation, we know that that would be reconsidered, that whole policy, but at this moment, it is not clear what's going to happen to so many individuals who are stuck on the other side of the border, who may not be able to find a lawyer to help advocate for them to come across. We understand there is going to be a shift to orderly processing, but what exactly does that look like? That still remains to be seen. That's just one example. There are many other practical implications we're still trying to figure out. In addition, we want to improve the system, not just return to how it was before. As I mentioned, in the time, for many years now, the immigration system has been showing us its many cracks. And in the years just before this past 4 years, we were saying at Tahirih, as many others were, that our system was already broken. We had so many issues with the way individuals were being processed. When they came to the southern border, they were being put into detention. Families, mothers with their children were being detained. The backlogs were already present in the immigration court and in the asylum office. We saw these last 4 years, it all just got much worse. An already broken system was being trampled upon and then stripped of any semblance of due process or any other protections for the legal rights of the individuals who need to access them. And at the same time, we're not satisfied with the simple revocation of the policies of these last 4 years. We see this right now as an opportunity, not a problem, but an opportunity to actually make the system more humane, more efficient, and more responsive to survivors' needs. What would it look like for us to actually have a border policy that embraced an individual, an immigrant, a survivor, and said, what is it that you need and how can we help you? That is our goal at Tahirih, not simply a revocation. To talk briefly about some of our priorities, as an organization, we would love to work on all of the things you heard us talk about today. And because we have a policy team here at Tahirih, we have a large direct services team, but we also have a policy team located in the DC area that focuses on federal immigration policy. The relationship between our program services and our policy team is that we observe the kinds of problems you heard about earlier that our clients are experiencing, that our advocates are experiencing, how hard it is for attorneys to counsel clients when even the attorneys don't know the answers to basic questions like, what is going to happen to my case? When will I be seen? And what laws will apply to me? When our attorneys can't answer those basic questions, we end up in a situation where we really have to press at the federal level and make changes to the policies here. So our policy team is deriving all of its priorities from the experiences of our services team. But we have to choose our priorities carefully. One of them right now is to focus on the asylum system. And I divide that into two categories. One is just basic access to the system itself. We have been and will continue to challenge any policy that keeps a survivor from accessing court, from being able to have their day in court, to stand in front of a judge or an asylum officer and say, this is why I'm here, why I'm afraid, and why I deserve to be in this country where I can finally be safe and free. In order to be able to have that day in court, Our clients and people like them need to be able to get into this country to have safety, to have housing, to have their mental health taken care of, and to be able to make their claim. But they can't make their claim if there are deterrence mechanisms in place, like family detention, which came up during the prior administration, during the Obama administration, specifically because of deterrence. In other words, family detention was instituted in order to keep individuals from wanting to be in the United States. That family detention needs to go, and many other policies like that that impact the likelihood that a survivor will ask for asylum need to be ended. I want to address bias in the court system, which we know is rampant. Also, lack of access to the assistance of counsel, and unreasonably accelerated or delayed cases. Now, that might sound confusing, but in fact, there are some rules on the books right now that would, if they were fully implemented, make it so that asylum seekers had to make their case within 15 days. That's unreasonable. There's no way to get an attorney to gather evidence, to compile your legal argumentation, all of that in that much time. In addition, it would be likely impossible for an asylum seeker to even be able to overcome the trauma she's facing and that she's experienced to be able to make her case. On the other hand, cases that take 7, 8, 9, 10 years are extremely unreasonable and leave our clients separated from their families for an incredibly long time. We also want to not only deal with access to the system, but also with who can qualify. We have seen in the last several years unprecedented changes that have narrowed the definition of who qualifies for asylum, and we really need to start working on that, not only to make sure that it becomes clear in the short term, but to also stop the flip-flopping that we see from one administration to the next. Some under one administration, it might expand. Under the next administration, it might contract. Our immigration policy should not rely on the political will of whoever is in office. In fact, we should have regulations and also laws on the books, statutes that tell us exactly who can qualify for asylum without so much ambiguity. That would make it easier for our clients. It would make it easier for us as a service organization, and it would actually be much better for the government. It would reduce the amount of time cases take in litigating issues that never should be litigated and should be clear as day. Another priority for us is to advocate for policies that actually increase the likelihood that immigrants will access protections designed to help them. So for immigrants who are seeking asylum, they've often experienced persecution, violence, or abuse across the border in another country. And so when they come here to the United States or when they're at the border seeking asylum, they're saying they need protection from something that happened to them overseas. But for many immigrants, the abuse and persecution and exploitation they have experienced has been right here in the United States. For them, there are protections in our laws under the Violence Against Women Act, also called VAWA, as well as a number of other areas where immigration law provides protection in the form of long-term status so that those individuals can get their feet under them and stop the cycle of violence. Right now, there are policies like arresting individuals in what are called sensitive locations, like courthouses, where they might be seeking protective orders, and other areas where they really shouldn't be arrested. Churches are another example, medical offices, places where survivors need to go to get protection, to get services, to get emergency help. Another policy we've seen in the last couple of years is an increase in the detention and removal or deportation of victims and witnesses. People who've experienced harm or who have witnessed harm should not be removed, should not be taken out of this country while cases against the perpetrators are pending. So these are some very basic asks. We feel these are things that our government should certainly stop doing in order to allow victims and witnesses to crimes like domestic violence, sexual assault, trafficking, and other forms of exploitation to be able to seek safety and find that safety here in the U.S. Reauthorizing the Violence Against Women Act, or VAWA, should be a no-brainer. It should be reauthorized. It doesn't expire or go away, but it needs to be reauthorized every 5 years in order to assure improvements to the law. The last time this should have happened, a couple of years ago, the House reauthorized it, but at the federal level in Congress, the Senate did not. We are looking now for a reauthorization of the Violence Against Women Act that is robust and that not only embraces what protections have been there, but improves the protections that exist. An example of an improvement we're looking for is that there's a cap currently on the number of people who can obtain a U visa. Those are individuals who have experienced certain very serious crimes and are participating and cooperating in the investigation and prosecution of those crimes. Right now, there's a cap on the number of people who can get the U visa that is far below the number who qualify. As a result, there are tens of thousands waiting and unable to get work permits, unable to get the status they deserve, which then makes it so they can't freely travel, they can't reunite with their children who might still be overseas, and other family members. And so we want to remove the cap on the number of U visa recipients that may qualify each year, and also ensure that survivors who qualify for work permits receive them at a very basic level, including because of what you heard from Adriana about what is happening with homelessness and lack of accessibility to mental health services and other issues. Immigrant survivors, more than anyone else right now, need to have work permits so that they're able to work above the table, to work with the protections that they need from exploitation and abuse in the workplace, and also because having a work permit allows them to get documentation, so an identification, basic thing like a piece of identification. Right now, you'd be surprised to know that most immigrants in the United States, even those who are undocumented, are paying taxes, yet the majority of them do not qualify for the benefits that they need in order to survive a pandemic like this, and also to get on their own 2 feet and away from abuse. Getting a work permit would really change the whole narrative for individuals in those situations. And so we are working at Tahirih through litigation, through advocacy with the administration, by working with members of Congress and hoping to educate them about the impact of policies like these, to try to ensure that everything you just heard, from policies that existed long before the last few years to policies that are brand new, are actually not only undone, but also that we begin to work toward a brighter and better future as a country, and that our immigration laws actually embrace the people that are here to help. Now with that, I will turn it back to Sahara, who is going to help us administer our question and answer period.
Adi, Adriana, and Archie, thank you so much for sharing your time with us today. There were a few questions in the chat that I'd love to share with you. The first one be, why would a client's asylum application be denied by a judge?
There are really a whole host of reasons why an application could be denied by a judge. One of the main reasons that we see is something called nexus, so the connection between the harm the person has either suffered or fears she will suffer, and what's called a protected ground. That's often hard to do because it requires something really tangible. That's the easiest way to do it. So-and-so said they're gonna do this to me because of this reason. Another really big reason why an application for asylum would be denied by a judge is, for instance, most of our clients would fall under the protected ground of particular social group. That is the really fuzzy, ambiguous, not defined term in our laws, but it is a protected ground. And through litigation, we've developed an analytical framework for it. However, there is still a lot that is left up to interpretation. One really bad decision can really blow us out of the water, and it can cause a lot of harm. Or even one decision that has one line in it that says domestic violence survivors should never be granted asylum. Judges can take that and run with it. So there are a whole host of reasons, but some of the big ones are because You don't define your particular social group properly, so therefore it's not a protected ground. And another really, really big one is because you haven't established the connection between the harm and that protected ground.
Thank you. You mentioned social groups. Do you mind expanding on what that could mean?
Sure. One of the common social groups that we see or that we can see is something called familial ties, family ties. So that is a group that is what's called cognizable. It's particular and it's a distinct. So it's got its definition. It has characteristics that are so closely held to you as a person that you should not be required to change it, because in order to avoid persecution. We can identify who that is. So that definition, you know who it is, and you can see it in that community. And in that community is really key there, because what is a particular social group in one community might not be the same thing in another community. So it's very, very fact specific and it's location specific.
Thank you. Do we have any idea of what near-term options are available for those subject to MPP and currently waiting for hearing dates given the reconsideration of MPP?
Archie, you want to elaborate on your head shake?
Yeah, I think I answered this in my comments. I don't think we do have any idea. I think at this time we are pressing and trying to get more information so that we can be more of a resource for individuals on the ground who are seeking that information. But right now, everything is very new and we don't have a clear sense of that yet.
Thanks, Archie. What impact, if any, do we foresee with respect to immigrants petitioning for protective orders? For instance, immigrant women who are reticent to request a protective order if it meant their significant other would be deported. Is the deportation of abusers less likely now?
I want to say no. I don't think that the deportation of abusers is less likely. That's a fear that we see all the time, where even though your partner might be harming you, you still love your partner, you still have that connection, or there could be other dynamics at play. But we see a lot where clients are reticent, to use the term used by the questioner, to seek that protection because of that reason. They're separate processes, they're separate courts, they're very separate. So that protective ground court that you go to, the protective order ground that you go to is a different court than an immigration court, which is also different from the ICE with guns that comes in, arrests people and detains them and then puts them on planes. So they're all very different. That's not to say there won't be an impact, because once there's a protective order issued against you, if you violate it, for instance, and police respond, then there's a record for you depending on where you are in the country, your community, your county, whether there's an agreement between the police and ICE to have what's called an ICE hold on you. So once you're done with whatever time you're supposed to serve in that particular jail, prison, whatever it is, ICE could have already been alerted and they could be sitting there ready to pick up the abuser. Doesn't happen everywhere, and there's no certainty of it happening. It can, though.
Thank you so much. I know we only have 2 minutes, so we'll save the rest of these questions. We're so grateful everyone was able to ask them and share them with us. I want to thank everyone for joining us today. A reminder that you'll be receiving a short survey at the end of the webinar, and we'll hope you'll share your thoughts with us. In the chat, you'll find a link to a blog post on Tahirih's website that provides an update on the administration's actions over this first month. You're welcome to check it out, share with your networks. We appreciate everyone on the call and hope you are still finding joy and community in these turbulent times. Please feel free to reach out with any questions, and we hope you all have a wonderful rest of your day. Thanks for joining.